In that financial interests are involved from the outset in the concept of fraud, this gives to penal practice the simplicity and clarity that is inherent in the reduction to money, but at the price of leaving the sense of justice very much unsatisfied. Out of the whole group of damages that may be inflicted by fraud, only that which can be expressed in money is subject to criminal prosecution and is thus specified as the one that requires expiation from the standpoint of the social order. Since it must be the intention of the law to punish every fraudulent destruction of personal values, this can be based only on the assumption that all such destructible values possess a money equivalent. The concept of wergild is again relevant here, though in a rudimentary form. If a negation of a personal value can be compensated for by giving money to the injured party, then it must be presupposed that this value can be reduced to money. Nonetheless, modern criminal law rejects the conclusion that fraudulent damage is sufficiently expiated by the exchange of money, yet with reference to the object of the act, the notion prevails that any fraudulently acquired value may be represented by a sum of money. Just as the need for greater explicitness in legal norms has led to the enormous restriction of personal values that can be protected against fraud to those expressible in money terms while the other values are reduced to negligible quantities, so the same need leads to corresponding regulations in civil law. Breach of promise and chicanery which may involve someone in considerable inconvenience and losses are, according to German law, no basis for a claim by the injured party unless the money value of the damage can be proven. I need mention here only some cases pointed out by lawyers themselves: the landlord who does not permit the tenant to use the garden despite his contractual right to do so, the traveler to whom the hotel owner refuses lodging despite written assent, the school principal with whom the teacher breaks his contract without being able to secure a substitute. All these people, although their claim to compensation is as clear as daylight, cannot raise this claim because the damage cannot be equated with a specific amount of money. Who could demonstrate the precise money equivalent of these subjective and objective inconveniences and impairments? If such a proof is not given, then the damages in question are only negligible quantities to the judge, they do not exist as far as he is concerned. In a tremendous number of instances in life the injured party has no rights at all. He has neither the moral satisfaction of seeing the person responsible for the damage prosecuted by the law nor the economic satisfaction of being compensated for his losses and his troubles. It must be emphasized once more that the presumption of the law is to secure all individuals' possessions against illegal damage, but this assurance does not include a whole series of goods whose value cannot be realized in money terms. It follows that the whole of this legal interpretation is based on the assumption that all personal goods do possess a money equivalent, with the obvious exception of the inviolability of the body and, in some respects, of matrimony, which are also guaranteed by law. The extraordinary simplification and uniformity of the legal system which this reduction to money interests implies has, in association with its actual domination, led to the fiction of the autocratic rule of money, a fiction that also corresponds to the peculiar practical indifference towards those values that cannot be expressed in money terms, even though they are theoretically recognized to be the highest values. It is interesting to observe how Roman law, in its middle period, took the opposite view in this respect. Monetary conviction, the same as was established in civil suits, was a penalty that went beyond the value of the object and was awarded to the injured party in order to compensate him for the particular insidiousness or malice from which he had to suffer by the defendant. The deposit that had been malevolently denied, the money held in trust for award by the guardian and similar obligations, were not simply refunded. In addition, the judge, and under certain circumstances the plaintiff, was entitled to determine compensation not only for the objective damage directly equivalent to a certain amount of money, but for malevolent violation of the personal legal sphere as a whole. Such regulations reflect the feeling that the personal values that the law is supposed to guarantee are not confined to the money value of the object. Rather, their violation requires a penalty over and above that. At the same time, however, this expiation is achieved by offering a certain amount of money, so that the damage that extends beyond the objective money interest is made good by money. In the one instance, money here plays a lesser role, but in the other a more important one, than is the case today. For that very reason, the present situation displays a combination of both of those typical tendencies that modern culture imposes upon the function of money. On the one hand, it gives money an importance that, as it were, makes it the world's soul of the universe of practical interests and which, in continuing its motion beyond its proper limits, stifles personal values as well. On the other hand, however, modern culture distances money from these personal values, makes its significance less and less compatible with all that is really personal, and suppresses the assertion of personal values rather than accept such an inadequate equivalent. Our sense of justice is less satisfied by the momentary effect of the concurrence of these two tendencies than it was in the Roman period, but this should not prevent us from being aware that we are concerned here with the combination of much more advanced cultural tendencies that reflect the antagonism and the irreconcilability of their directions in the insufficiency and low standards of some phenomena in which they are both simultaneously effective. Marriage by purchase. There are some analogies to the earlier state of affairs in which the whole person was compensated for by money in the particular development connected with the monetary purchase of women. Marriage by purchase, its extraordinary frequency in the history of civilized nations and today in less civilized countries, the extent of its variations and forms are all well known. We are interested here only in the conclusions that can be drawn from the facts as to the nature of values that are purchased. The feeling of degradation that modern man possesses concerning the purchase of a person for money or money equivalents is not always justified with reference to earlier historical circumstances. We have seen that, as long as the person has elevated himself above his species kind, and as long as money value has not yet been generalized into a completely colorless entity, both, as it were, stand in close proximity to one another, and the personal dignity of the early Germans certainly did not suffer from the fact that they permitted its value to be expressed in Wehrgeld. Marriage by purchase is a similar case. Ethnological data show that marriage by purchase is neither solely nor chiefly to be found only at the lowest stages of cultural development. One of the best experts in this area states that the uncivilized peoples who are unfamiliar with marriage by purchase are usually extraordinarily barbarous races. No matter how degrading the purchase of women may appear to be in higher cultures, it may enhance women's status under primitive conditions for two reasons. In the first place, marriage by purchase never occurs, as far as we know, in any kind of individualistic economy. Even at the very lowest level of culture, marriage by purchase is tied to rigid forms and formulas, consideration of family interests, exact conventions about the kind and amount of payment. The whole way in which it is carried out has a definite social character. This is evident from the fact that the groom is often entitled to demand a contribution to the price of the bride from each clansman, and that this is often distributed among the bride's relatives, just as among the Arabs. For example, the expiation money for a murder was collected from the whole tribe, from the clanship of the murderer. Among one Indian tribe, the suitor who has only half the necessary price for the bride is entitled to a partial marriage. That is, instead of taking the woman as slave in his own house, he must live in her house until he has paid in full. In many instances in which patriarchal and matriarchal conditions coexist, the patriarchal form is valid only after payment of the price for the bride, while the poor man has to accept the matriarchal form. There is no doubt that this businesslike attitude completely suppresses the individuality of the persons and their relationships. And yet the organization of marriage affairs as found in marriage by purchase signifies considerable progress when compared with the more brutal conditions of marriage by robbery or of completely primitive sexual relationships which, although not completely promiscuous, were nonetheless probably carried out without that stabilizing norm that was supplied in the socially regulated purchase of a wife. Time and time again, the development of mankind reaches stages at which the suppression of individuality is the unavoidable transitional point for its subsequent free development, at which the mere externality of the determinations of life favors spiritual growth, at which oppressive formation results in a reservoir of forces that later emerge as personal quality. Viewed from the ideal of fully developed individuality, such periods certainly appear to be brutal and undignified. However, they not only plant the positive germs